his family here today. He had more people here last week, but this was continued on my request. But he had a lot of family in from California last week. He does have support. He made an oath. He did give an interview with federal authorities in 2008. He made an oath to walk away from the life. If you listen to that tape that was provided, he says, "I'm retiring. I never thought I'd say this. I'm retiring. I'm giving up this lifestyle."
Doesn't he sustain a parole violation in like 2016, 2015?
The state puts that in their opposition. I don't have any indication that he went to prison in 2015, 2016. I know that was around the time he was having surgery for his cancer.
He provided the judgment of conviction in discovery for his conviction for a felon in possession of a firearm. He was arrested with both drugs and firearms, was convicted of 2013 arrest, 2015 conviction in California.
And was he incarcerated as a
I believe he did about 6 months on a 2-year extension.
Understood. Okay.
Alright, but there's no connection to this gang life or anything that they're alleging. Your Honor, he has been, before he got the cancer, he was making an honest living. As at home, he was arrested. He did not flee. He got the Markham notice. He could have ran if he wanted to. He's been investigating throughout his life, talking to this federal California. He's never ran. There's that if he is failed or not, that he is going to flee, he will return. If he was going to run, he would have did it back when he served with the mark.
Mr. Thank you. Request. State I'm going to turn to you to address the issues that were brought up, including the lack of corroboration and the fact that in his face value,
Yes, Your Honor, just so the court's aware, I was planning on handling the primary argument, and then Mr. Jackson was going to put the supplement that we talked about with the
Mr. Giacomo is going to address bail factor 6 or 7?
Yes.
Okay.
Okay. Your Honor, in listening to defense counsel's argument, one of the things he said is there are all these inconsistencies, but there is one constant, that Mr. Davis has consistently admitted to being the architect of the murder of Tupac Shakur. The state's position is that the proof is evident and the presumption is great. Now, to this case being 15 years old in terms of these statements, but not immunity. It's that we can't use his statements outside of that room unless he disavows and says that he was lying in making those statements, which is what precisely what happened here in the defense's moving me. But in 2008, we certainly couldn't have filed charges based on the 2008 statement. In the 2009 statement, we were unclear, in perfect candor of the court, of the circumstances surrounding that statement. Frankly, until Mr. Giacomo alluded to the fact that we're getting information now, even post-indictment, we got more information regarding the circumstances surrounding that statement only in the last few months. Clearly in the statement it says that you're not being promised anything. However, there are an abundance of caution. We could not proceed just based on that. And as the court should know, we didn't even submit that to the grand jury. We didn't submit that statement to the grand jury because we were just had some concerns that I think have been instead, but there were some concerns. So there's no immunity. There's this notion in defense counsel's community papers that this is all for entertainment, and I think if you listen to the 2008-2009 statement, you clearly hear that this is not for entertainment. I don't think that's true. So this court asked me about corroboration. Well, the first thing is that in any instance where we've had somebody confess to a murder, you usually don't have to corroborate with great detail their confession. But there is corroboration here. First, the whole setting. Mr. Davis was the leader of the Southside Compton Crips. Well, that's corroborated. Mr. Davis makes that statement. Detective Ladd, who was a patrol officer, then a gang detective in Compton from 1983 to 2000, corroborates that as well. Mr. Lee, who was a member of Mr. Davis's gang, corroborates that as well. Even Mr. Wright Jr. talks about Mr. Davis being a shot caller in that gang, or high-ranking member in that gang. Well, and trying to connect to the event. Well, Orlando Anderson was also a member of that gang. That's been corroborated multiple times. Orlando Anderson is the nephew of Mr. Davis. Corroborated, undisputed. Okay, so you have the fight that occurs at MGM, corroborated, undisputed, right? It's actually on video. So then you have Mr. Davis say, leading this group of people in a white Cadillac. Mr. Lee says he does see them in a white Cadillac shortly after the murder occurs, right? They see Terrence Brown in a white Cadillac shortly after. You have DeAndre Smith's statement about being in the Cadillac for the murder of Mr. Shakur. And you have Malcolm Greenridge's statement saying, I saw the white Cadillac go up to the vehicle. I saw a large arm come out of the vehicle and shoot at and into Mr. Shakur's vehicle. And, Your Honor, like, if taken at Mr. Davis's statement at face value, that would be enough. The state would submit for proof. But taking the connective tissue you have from Detective Black, from Malcolm Greenwich, from Mr. Lee, from we had one of the females who were out there in the street when this occurred. Part of Mr. Davis' statement is, yeah, there was these females, that's how we knew where Mr. Shakur was. There was these females yelling at the car, Tupac, Tupac. Well, what do we have? We actually brought one of those females. Like, yeah, we were talking at that bar this time. I think part of the struggle with this case, I think to wrap your head around it is, the question is, why would Mr. Davis admit to this in public, right? Multiple reasons. He could have been under the fault. That doesn't immunize himself in and of itself. But he also gives an explanation in one of the trailers, I guess, for the Death Row Chronicles, one of the NBC videos. And it's addressed a little bit by defense counsel, which is, I have cancer, I have nothing left to lose. Because he was given a serious diagnosis of cancer back in 2017, and he says, I want to set the record straight. When we talk about the book, about we can't prove what he wrote versus what his mother wrote, but again, we just refer back to Mr. Davis' own statement on video where he says, while holding the book, this is the truth. I was the only person that was there. This is the truth. It is stamped home away. Those are his words, not mine. And so he's saying, and we're saying, and I am saying, and I am validating everything that's in here. The problem for defense is that their defense is our client's a liar. That's the defense. Our client is a liar. He lied to police in 2008. He lied to the police in 2009. He lied to the Death Row Chronicles in 2007. He lied to his book in 2008. He lied in his YouTube interviews from 2019 to 2022. And Mr. Roy says this is not real life, and I take issue with that. The family of Mr. Shakur, this is very much real life. This is very much real life. So I do take issue with that. And Your Honor, there's something else very disturbing. It's like this kind of character assassination of the victim in this case. In the reply brief, it says Mr. Shakur was a violent person. Certainly, he got into a fist fight. He and some other guy jumped on a guy for 20 seconds. That doesn't come with a death penalty. We have to be a little more precise when we're talking about the conviction, just as we would be with Mr. Davis. Certainly more precise when we're talking about the convictions of Mr. Shakur. And the other thing I'd ask is, what relevance does that have? It certainly doesn't factor into a Daniels analysis in terms of self-defense. It's just there to impugn the character of somebody who is no longer here. Lastly, Your Honor, I want to talk about Mr. Lee, because Mr. Lee does corroborate some of the stuff that's done in this case. And they say Mr. Lee is looking for 15 minutes of fame. Well, I think it's a mischaracterization of what that YouTube video says. I think the YouTube video, the person who runs that channel says that, hey, I'm trying to reach out to him, I'm trying to get him to come on. He hasn't gone on. But more importantly, the person who that Mr. Lee has information about this murder in 1996 officially says, no, I don't know anything about it. Who redirects the police to Mr. Lee after the decade has gone by? It is Mr. Davis in his interview when he's giving his proffer.
Okay, again, the equality kept talking and writing, and now here he is as the defendant. The big question now for this judge, should he be allowed to be out on bail pending trial? We'll find out. Let's head back in. Again, the quality, not great, but you can hear. Julia suggests you don't look at the camera, the TV as much, so you don't...
Only time I'd ever say don't look directly at the TV.
Yeah.
Definitely listen, because there's some important stuff coming out.
Absolutely. And we'll see what this judge decides. But both sides, boy, it's very entertaining. Let's watch.
That's Mr. Davis who says that to the police. So Mr. Davis is the one turning the attention to Mr. Lee. It's not Mr. Lee that had come forward. It was Mr. Davis that said, hey, he has information. He can corroborate my story. And he did. And lastly, Your Honor, and then Mr. Giacomo, is this notion that somehow this could be self-defense. Mr. Davis says, I got a firearm from Eric Martin for the express purpose of shooting people. We drove to Club 660 for the express purpose of a violent confrontation. And what Mr. Davis says is, look, if it didn't go that way, it could have been fake Valentine's Day massacre there. And what is that referring to? Obviously, a murder in Chicago where 7 gang members were killed by a violent gang. So that was the mentality. And then, when he is driving one way on Flamingo and Mr. Shakur's car is driving another way, it is he, in every iteration of his story, says, we made a U-turn to go after them. And what are we to believe the purpose of that U-turn was? Was it a Yalta-like peace conference? Absolutely not. They had the firearm provided by Mr. Davis to the shooter, and what happens? The logical thing happens. What's Mr. Shakur doing during this time? What's Mr. Knight doing during this time? Indisputably, and according to Mr. Greenwich and to the female they were talking to, they were going to the club to perform and to party. They were not the ones seeking the violent confrontation at this point. There was one person who forced a lethal confrontation, and that is Mr. Davis. Self-defense is not available to him under these facts. I think
when I listen to Mr. Arroyo here, it's a discussion about there's no threat to these individuals because they've all been on YouTube telling the story. If he wanted to harm these people, he could have done it because they're all on YouTube. But he's missing the central fact here because apparently every gangbanger on earth can get on YouTube and talk about crimes. But when it comes to talking to a police officer, that is a unique thing. It's a thing that will get you killed. And so why did I give you the exhibits? And one of which I provided a disc to your clerk today of Exhibit 8. I had that filed under seal. And I'm somewhat disappointed with Mr. Arroyo for publicly to put a witness. I'm going to talk about him as a high-level multi-group member. And here, when you look at the 3 facts we put in front of the court, which is that Mr. Westbrook, and I will say it was probably both unethical and ridiculously dangerous to provide a list of 39 people and tell Mr. Davis that these are people that have provided information to the police about this situation. Mr. Davis then has a conversation with his son, and his son requests that list from Mr. Davis, and he says, well, I can get it to you, or maybe Mr. Westbrook can get it to you. I don't believe from the nature of that picture that Mr. Westbrook provided it to Duane Davis Jr. I believe because of the way you see the folds in the paper that Mr. Davis mailed that list to his son. What was the purpose of mailing that list of 39? You have the phone call. And I agree with Mr. Arroyo. Mr. Davis, I'm not the newspaper. I'm media, and God knows if I were writing the stories, I'd get it correct. I never alleged that Mr. Davis and Vermont put under oath to talk about the number of times they discussed. These people are people that have provided information to the police. And then there's a phone call in which Mr. Jr., Duane Davis Jr., tells his father, hey, I got some news for you, that there is a guy, and there's some confusion on Mr. Davis's part about he's put up a green light, which in Mr. Davis's own words means an order to kill on our side. I took that statement to mean that anybody on that list who was a Southside Crip was at risk of being killed. They take it as, oh no, they're going to kill a bunch of Southside Crip people. They put a green light, the mob put a green light on us. Well, if that's true, then why is Mr. Davis's reaction during that point?
All right, both sides going.
Stated that he was basically a fixer for a gang, and without implicating him in other crimes during this intervening period, it is not like he went and got a different job. So I think they don't get very far with an argument because he was still involved, at least tangentially, with the very gang that he was involved in at the heart of this Tupac murder.
Yeah, at the end of the day, he's accused of just ordering a hit, not hitting. Not the fact that he's old and 60, he can still order anything he wants.
That's right.
So let's get a break and get you back to the hearing for more right after this.
We were born in war, and this is war, and all that was other things. Why is he so excited? Like him and his family members are about to be killed. I then gave the court the high-ranking mob Pyru members' statement to police. Yes, all these people have been on YouTube, and none of them are of any danger because everybody apparently should be on YouTube. But nobody knew that this member had spoken to Detective Mogg. More importantly, he brings a crucial piece of corroboration that nobody knew. That he is 662. He sees the white Cadillac, and that he knew that Southside was present at 662 prior to the homicide of Tupac Shakur. Meaning he's a critical piece of corroboration. And why is that important? Yes, everybody has said this in social media from 2017 on. But you now know that every single fact that every witness has reported since 2017 on YouTube was reported by Duane Davis in 2008 and 2009. Which means every witness on YouTube has corroborated what he said in an admissible statement that we now know is admissible to Detective Dan Long in 2009. And why those witnesses are so important is because there is no to this particular crime based upon the statements he's made in 2017. Because it's not until 2011 that Keefe publishes his book and puts all this information out there. And thus, Judge, why is this important? Well, when you hear what this high-ranking member, they find out there's a statement to Mogg, and they're going to put it on the street. What does Mr. Davis say? He basically implies that Mogg will kill this guy on their own because he talked to Cliff Mogg. And that gives you knowledge of what it is they were doing when they disseminated that list of 39 gang members who allegedly provided information to the police. Why were they sending that out as a picture and disseminating it publicly? It's because he knew he doesn't have to issue the green light. He knows what the culture is because he was born in it, he grew up in it, and I dispute he ever left it. You listen to those calls and you know that he is a gang member to the core, that he has their mores, their values, and he presents a clear and dangerous threat to our community. And that he cause harm to those 39 people on that list. He is making efforts to cause harm to the high-ranking mob Pyru gang member. He doesn't need to issue an order. He just needs to prove to the world that they talked to the police, and every one of them is at risk of death. Why the federal government came in and provided money to Mr. Lee so that he could move his location. I would suggest to the court that not only is the proof is evident, the result is great, but that he presents a very, very high danger to the community, and thus he must stay in custody.
Thank you, Mr. DiGiacomo. Mr. Arroyo, I'll give you a final word as it was your motion.
Mr. DiGiacomo has taken a huge leap. Multiple YouTube interviews from 4 years ago up to a couple of days ago. That's why I asked your court to review it. Nothing he says in that statement has been said on YouTube for the whole world to see. Right? This is a person that says he's a former gang member. There's nothing in that statement that has not been said on the public forum. That the statement about seeing that they say now corroborates a huge fact in this case about seeing Duane at the 662 Club. In one interview on YouTube, he says, "Oh, I saw him," and in the next interview, he says, "I never said I saw him." So he's even inconsistent in his own YouTube statements. And this is not a hidden witness that we had no idea that was. Just Google him. See how many times he comes. Right? We're not exposing some high-level secret government witness. He's out there giving a press tour every day, trying to make a couple of bucks on this case. In this case, trying to make a couple of bucks on this case. We're going to talk about putting people in danger. Let's talk about this green light call. All right. The allegation is that Mr. Davis's son says, "Hey, I heard something on the street from a guy named B. Brew." Right? That B. Brew is saying it's on. It's a green light on our side. I don't need to pull in a gang expert in to know that B. Brew is a blood nickname. It's not a crypt nickname. So now by putting that, now every blood gang member in California knows that it's Mr. Davis's son that's putting out this information. They've made their family more in danger now of retaliation. The threat is against Mr. Davis, right? There's a green light on our side, on our family. He doesn't even know what his son is talking about in that phone call. He's not making any threats. He's not saying, "Oh yeah, go, make sure that it gets carried out." He's saying, "What? What are you talking about? Huh?" He can't even really hear what's being said. And the court is listening to that phone call because I think the way
so many of your clients' words and repeat is the way that he speaks, because I provided, 20 hours worth of report. So I'm very familiar with that. I heard everything that was provided to him.
The way Mr. DiGiacomo characterizes it, I think, is unfair and inaccurate. He's taking a huge jump and taking liberties with what is actually there to support these allegations. I just want to say, who put this information out in the public? It wasn't Duane. It was Detective Keefe in 2011. He put all these people's names out there in the public. This was never about finding the truth. Detective Keefe was out there to make a buck on this story. Like I said, this is the problem with this case. They're putting this information out into the public since 2011, and it was a cop that put this information out into the public first. Duane was working with the feds prior to them bringing Duane in. He was part of the crew that gave information on Duane in that 2000. So they talk about him and other members, and that is why Duane was first brought into this. I just think here some of these things that were said, and like I said, this goes back to corroborate believability. They talk about this massacre that take place at the 662 Club. I mean, it's just incredible to believe that Mr. Davis and four guys go with one gun to a club 662 full of non-powerful members and armed security and metros there, and the four of them with one gun is going to take out a whole army of people. And this is why I said that the statements are unbelievable. They're puffery, they're dramatized, they were set a certain way to sell books, to sell clicks on YouTube. There is no corroboration. Statements that Lee says about DeAndre Smith, we believe are inadmissible. They're inconsistent that, nobody says he was a shooter, and then he is the shooter, but at trial, we believe it will be inadmissible, and that he wasn't doing it, it wasn't a statement against interest, he's actually bragging. That's what Detective Keefe says, actually all these people are bragging, trying to get their stripes. So this is actually a statement, I guess, in his interest, but we believe it will be inadmissible at trial, and it is not credible. Like I said, there is no corroboration. There are serious problems. Even if you take the words at face value, there's still an issue whether or not this rises to the level of first degree. Mr. Shakur, I'm not trying to discredit Mr. Shakur's legacy, name, or anything, but his history is relevant to a self-defense claim if we go to trial on that issue. All right, what is known about him? What his violent history? It's very public. His violent. What was known at the time? He's in rap songs bragging about being a mob Pyro blood member. He's gonna kill all his rivals. I mean, this is stuff that was known to the public. It is. I'm not trying to discredit his name in any way. It's relevant for this court's consideration today, Your Honor.
All right, thank you, Mr. Arroyo. Before I rule, I did want to compliment both sides on their excellent advocacy here.
All right, we are going to hit the
Please. First issue that's before me is whether there's proof evident presumption great to justify holding Mr. Davis here without bail. At this time, the court declines to find that, citing the age of the case as well as the lack of physical evidence. I'm not commenting on the strength of the state's case. What I'm saying is that this doesn't meet the Nevada Supreme Court in Sewell versus State, which bars the district court from relying on conjecture and inferences and denying bail. At that point, I do turn to the bail factors, and ultimately, I do find that very few of these will weigh in favor of release of your client, Mr. Arroyo. The length of residence, I do admit he has lived in Henderson since he finished that parole violation. This is a factor that does weigh for defendant. Status and history of employment is the second factor. His life, it appears to have been largely illegal employment. He made a living talking about his past life as a leader. Detail that I find weighs in favor of the state. The relationship with I think that does weigh for the defense. He does have numerous jail calls that show he maintains these close relationships with his family. When I look at his overall reputation, character, and mental condition, his reputation, although it may be older, leader of a gang, he makes his money, as I said, talking about the victim's death in this matter. I behind him based on what I defense the factor that weighs for the state. His prior record is significant but old. On supervision, this is a factor that weighs for the state. I apologize. The identity of responsible members of the community who would vouch for the reliability of him. We do have a note from his neighbor attached. However, that note reveals that the neighbor doesn't know anything about him, and that's mainly the gist of the note, is that she didn't know that he had this background. Ultimately, this is a factor that weighs for the state. We don't have responsible people vouching for Mr. Davis's credibility and character. The nature of the offense, the probability of connection, the likely sentence. Overall, I find the nature of the offense is obviously the most serious that we face in the criminal justice system. The likely sentence here is very high given the existing law at the time when this offense was committed. Probability of conviction, one of the biggest things in evaluating a case is, does the defendant give a statement? Yes, he gives many statements here that connect him to this crime, and so I think that's a factor that weighs for the state. In this jury, people in this case, as the state has indicated. Laid out by Mr. Giacomo regarding the jail call. They do cause the court concern. Based on failure to appear, I do find ultimately he didn't flee when he was served with this marker note. Entirely cooperative as he didn't sign that mark. The fact that he didn't leave at that point sort of speaks to the fact that evidence thought that there was this repeated instance that he was in this horrible death. While I am concerned about his medical issues, those can be handled by CCDC. If any issues arise, let me know. I'm going to set $50,000 with the source hearing as well as house arrest. We'll see everyone back for the status check on trial readiness that we previously set. Anything you're on your side?
No.
Okay.
Okay.